I'm going to start this talk speaking to you about two recent exonerations that we had this year, and then kind of segue into our legislative work that we've done this past session that kind of really links together our casework and the policy work. So in June 27th of just this year, less than a month ago, we were able to bring home and exonerate Royal Clark. So Mr. Clark, this was a case out of Jefferson Parish in Louisiana, and he was convicted of a 2001 armed robbery case. And he served 17 years in prison for a crime that he did not commit. And the way we were able to bring him home was that there were fingerprints that were left at the scene that was never actually tested. At the time in 2001 when they recovered these prints, and this was an armed robbery of a Burger King. And this is a bit of a funny story. The alleged, the armed robber comes into the Burger King in Tarrytown. It's right before closing. He orders a full meal, maybe a Happy Meal or a full meal. He eats it, and then he throws away the trash, but the only thing he doesn't discard is the drinking cup. And then he drinks out of the drinking cup, leaves it on the table that he was sitting in, goes up to the cashier, takes out a gun, and robs the Burger King and takes about $3,000 from its employees. But he leaves that drinking cup. And when the police came later that evening, they were able to recover prints from it, but they said the prints were not actually usable, and so they couldn't actually run it through any sort of state or national fingerprint databases. And so this case actually started out as a DNA case for us. DNA technology has gotten so advanced that we're able to take latent fingerprints, right, the residue, the latent fingerprints, and run DNA samples out of it. And so it started out as a DNA case, but then we thought, why don't we just try to run this through the national database? Why don't we just try to run the prints through the state database? And thankfully, the Jefferson Parish District Attorney agreed to do that with us. And so when we did, it actually hit another individual, another man who was actually a serial armed robber right in this neighborhood in the Gretna, Tarrytown area. And he had committed a series of armed robberies at the Family Dollar store, at the Burger King, and another little local grocery store. He was just going around committing these robberies in the span of 2 or 3 years. And those fingerprints actually from that Burger King cup matched this other guy. And we know that there was no other person with Royal Clark that night. And we know that the fingerprints that were located on that cup was definitively used by the robber. And so that's the way we were able to bring Mr. Royal Clark home on June 27th. Now, he went to prison. Because they did not run the fingerprint latent prints through the system, there was no physical evidence actually linking him right to the crime. The only thing they had was the eyewitness testimony of the employees. There were about 7 or 8 people working that night, some in the back in the cooking area, some in the front. As I said, it was at the closing, so people were really busy trying to get out of there, mopping the floors and all of that. And so there were only 2 employees that night who were able to make a positive identification. And even if their positive identification was a little bit uncertain, right? They picked him out, they picked Royal Clark out of a lineup, at a photographic lineup, but they weren't actually 100% sure. And by the time trial came around, there was actually only 1 employee who was able to get up on the stand and say, I think it was him, Mr. Royal Clark, who committed this offense. So he was convicted based on essentially a single eyewitness identification. That's Mr. Royal Clark. Another case from earlier this year, Mr. Archie Williams, he was exonerated on March 21st in 2019. And Archie's case dates back 36 years. This is a case from 1981. And he served time in prison, 36 years for a rape that he did not commit. And again, much like Royal's case, Archie's case was a single eyewitness case. The victim, right? The victim mistakenly identified Archie and said, that is the man who raped me. But again, like in Royal's case, there were fingerprint evidence that was left at the scene. There was a stabbing that happened during this rape, and so there were fingerprints left on blood at the scene of the crime, which was our home, the victim's home. And again, these fingerprints, they were run through the database back in 1981, but it made no hits. There was no one who came up positive for those hits. And those fingerprints did not match Archie Williams' prints. And so it was highly suspicious. So like, who else was with Archie, right, to have committed this offense? Because there are these prints in this home that doesn't match the victim, her family members, or anyone else that they knew who would have come to their house before this crime happened. And so again, this case started out as a DNA case, right? There was blood, there was fingerprints, and so we're gonna run those through, we're gonna make it a DNA case. And again, the fingerprints, because we had the prints, and because we were able to use the technology, advanced technology, to get a better resolution of the prints, we asked the DA, Hiller Moore, here in Baton Rouge, whether or not we can agree to run these prints through the national database system. And again, thankfully, due to the DA's participation and cooperation, we did that. And it again hit another individual. It showed that Archie Williams was not the person who was with the victim back in 1981. It hit another man who actually confessed to committing 4 different rapes right around the same time, right around the same neighborhood in 1981 and 1982. And this man was eventually convicted. He confessed to his crimes. There was physical evidence actually showing him that he was connected, not necessarily to the case that Archie was convicted of, but other rapes that were committed in a similar fashion. And he was sentenced to life in prison in Angola and ended up dying in Angola in 1996. But these were 2 cases where the individuals were exonerated, right, based on physical evidence, fingerprints, but they were placed there. They were incarcerated and wrongfully convicted based on a mistaken identification. And I have to tell you that one of the leading causes of wrongful convictions in our country is mistaken identifications. 70% of DNA exonerations across our country is a result of mistaken identifications. Men and women are being placed in prison, right, wrongfully convicted because someone said, I think that person did it. And we're not saying that the victims were malicious. We're saying they simply made a mistake. And we know mistakes happen all the time because our memory doesn't work like a video recorder, it doesn't work like a videotape, right? Especially in a traumatic event, right? Especially in a moment when you're scared or startled, an event that's fleeting and you're confronted with a stranger, your memory does funny things, right? You think you're taking in information as much as possible, but in fact, we are not. We're taking selective information in. And so because we have these cases, and just going back to the numbers for a second, in Louisiana, 14 out of 15 DNA exonerations, those individuals, those men were placed in prison and sentenced to life based on eyewitness mistakes, right? And so because we know eyewitness mistakes is so prevalent in our criminal legal system, one of the first things we did last year in 2018 legislative session is that we worked with the DA's Association, we worked with the Sheriff's Association to pass a comprehensive eyewitness identification procedure bill that kind of streamlined how law enforcement should conduct their eyewitness identification procedures. Because you have to think of eyewitness identification or eyewitness evidence as any type of evidence, like as a trace evidence, right? As fingerprint evidence, as blood evidence, as any sort of evidence that the officers would have to go and collect from the scene, right? So when there's an eyewitness evidence, an officer goes to the eyewitness and say, tell me what happened. Give me a description of the perpetrator. What did you see? What was the lighting like? That officer is collecting evidence, right, from the witness's mind, from their memory. And the way the officer asks questions, right, is it leading or not leading? The way the officer, whether or not the witness had a chance to talk to other witnesses at the scene, right, and discuss certain details of the scene before being first interviewed by the officers, these are all factors that can impact the creation of one's memory. And so we worked with the police, we worked with the law enforcement to develop for Louisiana evidence-based best practices. And these practices did not come out of thin air. This is not Innocence Project New Orleans special processes. These were nationally approved, nationally tested, evidence-based practices, and that require the law enforcement to do 4 things when they're collecting this eyewitness evidence. The first thing they have to do is obviously when they call a witness down to the police station, or when they call a witness to say, I'm coming over to show you a photo array or to conduct an eyewitness identification procedure, you have to make sure that you don't tell them that you have a suspect, right? You have to give them neutral instructions. Because what happens is that when a witness, especially a victim, gets a call a week later, 2 days later, a month later, and the detective says, I'm coming to your house, or can you come down to the station? We have a suspect. We think we have him. The witness comes down, and all of a sudden, the witness is filled with anticipation, and she feels like, or he feels like, they've done their job. Now it's my job to pick out the right person. And they show him 6 photographs, and they sit there and they compare them, and they're looking at each of them, and they think, well, the one that fits the best, not the one that actually perpetrated this crime against me, the one I think that fits the best my memory is 1 or 3 or 4. And that's how wrongful identifications happen, right? Not because the witness is lying, but because she genuinely wants to help the police, but in their eagerness to help, right? They make a deductive reasoning, right? This is not a multiple choice examination, right? There's a right or wrong answer. I mean, you have to get it right? It's not a deductive reasoning, like this is the best answer, or all of the above, or none of the above, right? And so, that's one of the first things the law enforcement has to do, in neutral instructions, telling the witness, hey, I want you to come down and take a look at this photo array. I just want to let you know the suspect may or may not be in this array. May or may not be there, right? We just want you to take a look at it to see whether you can pick someone out. If you don't pick someone out, don't worry about it. If you do pick someone out, you know what? We're going to continue to investigate this case. This is not the end of the case. We're going to continue to work on this case, continue to make sure that we have the right person. Right? That's one of the first things that law enforcement has to do. Second thing is double blind, right? The person who's conducting the eyewitness identification procedure cannot know who the suspect is in the photo array. So the primary detective, the main detective on the case, cannot be the person who's actually conducting the procedure with the witness. Because as human beings, we have these subtle cues that we can give, right? We have seen through many, many different tests, right? Both in the lab and outside. Psychologists have done this through almost nearly 40 years of scientific research and testing, that we inadvertently send cues to each other, and we're all social human beings, and we pick up on these cues. Even if the detective is trying to be really stone-faced and not do anything, there might be a little bit of a twitch in his eye or a twitch in his move to indicate the person either has picked the right person or has not picked the right person, right? I've read many police reports where the officer would say something like, well, look carefully. Why don't you take your time, leading the witness to believe that they're almost close to getting a match, right? Kind of encouraging them to pick someone from a lineup, right? So the second thing, making sure that the officer who's conducting the eyewitness identification procedure actually doesn't know who the suspect is, so they can't inadvertently lead that witness on. The third thing is recording the confidence statement of the witness if that witness makes an identification. Because we very much know that confidence does not equate to accuracy, right? I don't know how many of you are married, but if you're in a marital relationship, you argue with your spouse, and you're really confident that, the ketchup bottle was on the refrigerator door, right? That's where I left it, that's where I last saw it. You can argue back and forth about it, but it's not where you left it, right? So accuracy and confidence has no correlation. But at the end of the day, what happens is that when a witness makes a selection, right, and an eyewitness identification procedure that happens, 6 months, a year before the trial, there's all these feedback that happens to the witness, right? Because they're going to go meet with the DA, they're going to go over their testimony, they're going to possibly go to court, see the defendant in court, right? Either at a pretrial motions hearing or maybe at a trial date that gets reset. And so there's all these feedback that kind of bolsters their confidence. And we have seen through testing, through research, that witnesses who were about, 95% sure of their ID, all of a sudden at trial they're 100% sure, right? That they would never forget that man's face or that woman's face. That face is like blazoned, burned into my memory, right? I mean, we saw this in one of our other exonerees, Wilbert Jones from Baton Rouge. Wilbert did 46 years for a rape he did not commit. It was a rape from 1971, and Wilbert was exonerated in October of 2018, last year. And in that case, the victim, it's a single eyewitness case, the victim said when she made the identification, she said, I am not sure if this is the right guy. I'm about 98% sure, right? That's what she said. Later on, when she went home, she even called the detective and said, listen, I just want to reiterate that I'm not sure I made the right selection. One, the guy that I picked is much shorter than my rapist, as I remember him. And two, this was a live lineup that happened in 1971. And the folks who participated in the lineup was able to speak because the victim's rapist, spoke to her during the crime. And so she also said, the man that I picked, his voice sounded different. His voice was much softer than the guy, right? And so there were definitely differences. She articulated, and she was really uncertain on the day that she made the positive ID. But when trial happened 6 months later, she got on the stand and she said, I am 100% positive that is the man. And when the defense attorney tried to cross-examine her about the height differential, she said, no, I was wrong about the height. I know he was that height, right? Her confidence was bolstered, right, by her positive identification and she convinced herself, right, that she was correct, that she could not be mistaken, right? And so just recording the confidence statement right when they make the ID is really important because we know it tends to inflate over time. And so those are some of the things that we worked together with the law enforcement to get passed in 2018, and that went into effect this past January. So every single law enforcement agency, I think there's like 350 some law enforcement agency in Louisiana, counting all the sheriff's offices, all the municipality offices, and they all have to have their own policy. They have to have a written policy about how they're going to conduct their eyewitness identifications, taking into consideration these model procedures. And the Louisiana Sheriff's Association actually wrote a model policy, which I think most jurisdictions are adopting. So this went into effect in January this year. These policies should be made available to the public. It should be available to the public it should have been by end of March of this year. So law enforcement is doing things a little bit differently, right? To try to ensure that the evidence they're collecting is not going to be tainted, right? And they're going to preserve this eyewitness evidence like they preserve other types of trace evidence, right? But the other part about Louisiana and eyewitness identification is that until this legislative session, we were one of two states, the other state being Nebraska. We're always one of two, right? One of two with Oregon, one of two with Nebraska this time around. So we were one of two where an eyewitness expert, and who is an eyewitness expert? A psychologist or psychiatrist could not testify in a trial, either for the defense or for the state. And honestly, you couldn't testify in a civil trial or a criminal trial about some of the frailties that are involved in eyewitness identification, some of the things that happen in our memory that makes us really unreliable witnesses, right, to crimes that are perpetuated against you, right? And so There's been, as I said, about 40 years of scientific research, starting in the 1970s, right, that's been studying human memory and how we perceive information, how we store information, and then how we later retell that information, right? And this 40 years of scientific research have shown that there are a lot of misconceptions we hold about how our memory works, right? People think that when you experience something so emotional and powerful, like a crime, right? That because the intensity of that emotion and experience, that moment is emblazoned in your mind, that you actually do, because you're so alert, right, that you actually take in the information and store the information in your mind much more clearly and much more, with more lucidity, right? But that's actually not true. That is actually not true. In fact, whenever there's a weapon involved in any crime, like an armed robbery with a gun or a knife, studies have shown that more often than not, we're not looking at the perpetrator's face, we're actually looking at the gun or the knife. Because you're making sure that the gun and the knife is not going to be used against you. So more often than not, the victims can describe the gun much more clearly and the knife much more clearly than the face, right? A lot of times people have these composite drawings, right? The police officer brings the victim in, later that night or the next day and say, let's get down to the nitty-gritty details of how the suspect looked like. Let's do a composite drawing together. We have a program where you can pick out the nose, pick out the eyebrows, pick out the chin, pick out the cheek. But studies have shown we don't take faces in piecemeal by how the nose looks or the eyes look. We take faces in holistically, right? We recognize people with their holistic face, not necessarily because of their nose, right? Unless they have a really pronounced and distinctive nose, right? I mean, if your perpetrator had a very distinctive nose or your perpetrator had a very distinctive tattoo, right? That's another thing. But generally, if you don't have a incredibly distinctive feature on your face, this is not how we take in our information, right? We take in information as a face. And so a composite drawing can be really misleading. In Archie Williams' case, there were two composite drawings, right? And also in Royal Clark's case, actually in Wilbur Jones's case, there was a composite drawing, right? And when you look at these composite drawings with the men who were eventually convicted, they don't look anything like each other, actually. Another thing is cross-racial identification, right? Believe it or not, we're better at recognizing faces from our own race, right? And so if you're white, you're going to have some difficulty recognizing and picking out black faces. If you're Asian, you may have some difficulty, right, pointing out or recognizing faces from the right. So we actually, and it's a conditional thing, it's an environmental thing that we grow up with, right? And so some of these things, the juries are not necessarily aware of. And so a psychologist can come and testify and educate the juror about some of these factors if these factors are relevant and present in a particular case. And Louisiana, like I said, was one of two states where there was a per se prohibition. It was a jurisprudential law. It was a case law from 1982. Louisiana Supreme Court said experts cannot testify about memory or eyewitness identification factors because that would have an undue influence on the jury, right? They would be like telling the jurors that that witness is not credible, right? But all of the other states, based on the scientific research, have realized that the experts are not going to give the ultimate final answer as to whether or not that witness is believable or reliable. That's not their job, right? In fact, they can't do that in any of these cases. What they can do is talk about the scientific research having to do with weapons focus. They can talk about the scientific research having to do with the correlation or lack of correlation between confidence and accuracy, right? They can talk about the scientific research behind cross-racial identification. They can talk about the scientific research behind at what distance you actually cannot see anything, right? Because a lot of times the witness may say, oh, I was half a block down the road, or I was, 100 yards, 200 yards, and I was able to see that face. There are actual tests, that show that when you are a foot away, this is how the face looks like. When you're 10 feet away, you're blurry, your face, the image of that face gets a little bit more blurry. If you're half a block away, this is how the image looks like to you, right? If you have a good enough vision, right? If you're not using corrective lenses. And so these are some of the things that an expert can educate the jurors so they can reach a correct verdict, right? The most informed verdict in order to prevent wrongful convictions from happening. And so this was a bill that we introduced with the help from a representative in New Orleans, and then we were able to work with the DA's Association to get it passed this session. And so Louisiana is no longer the only one of 2 states, now it's just Nebraska hanging by themselves. So starting in June, both defense and prosecutor can introduce expert testimony. Now, it doesn't mean expert testimony comes in at every trial where an eyewitness identification exists, because the law states that expert testimony may be admitted, and it's at the discretion of the judge. It may be admitted in cases where there is no physical evidence, right, linking the defendant to the crime. If it's a rape case, and if we have DNA from a rape kit, that's probably not the best case to use an expert, right? Because we have that rape kit to corroborate the testimony of the eyewitness, right? If it's an armed robbery case and we have, the weapon that was used, right, or proceeds of the robbery, let's say that was recovered, and if the fingerprints link up to the perpetrator, that probably is not the best case to use an eyewitness identification expert. And so the cases in which an eyewitness ID expert would be useful are in those cases where there only is a victim or a witness and their eyewitness identification testimony. And we're not saying eyewitness identification testimony is always wrong. It's not. It's absolutely not true. If you have familiarity, right, with a perpetrator, if you've seen them before, if you actually know them, right, eyewitness identification can be very, very powerful, right? If it's an armed robbery of a local store and the store owner has seen this person come to their store numerous times, right, over several months, and if that person eventually robs that store, that ID probably could be very, very strong, right? And defense probably don't want to be calling an eyewitness identification expert in that case. And because this evidence, because the judge is the doorkeeper, is the gatekeeper of allowing this evidence in, the judge can decide that that is not the right case in which this evidence should be used. Thank you so much.
So in this law that you passed, how much of this is reversible error? If the cop does not give the proper setup, but does not do any of this, is that enough to throw the case out?
No, oh yes, so the question is, if the police officer doesn't use the procedures, right, the now mandated best practices, does that mean that the case gets thrown out, right? And that's not how it works. There is a provision in the law where the judge can take into consideration, right, whether or not the procedures were used. And the judge can decide on a case-by-case basis whether or not to suppress the ID or not suppress the ID based on the evidence that comes in. And so it's not an automatic thing, it's completely up to the judge. Yeah. And based on the circumstances of the case and looking at the totality of the cases.
But I can't bring it up on appeal and say...
you
What's the
can't.
question again?
He wants to know whether or not you can bring it up on appeal. So you mean for individuals who were convicted prior to the passage of the law, whether or not they can bring this up as a new science issue.
Or even afterwards.
Even afterwards, right. And so, I mean, in post-conviction, you can raise this issue if you thought that this was going to be the issue that would make or break your case, right? Because the way post-conviction works is that you can't rehash the issues that you litigated in trial and pre-trial, right? In post-conviction litigation, which is where we spend most of our time, you have to come to court with new pieces of evidence, right? New pieces of evidence that sheds completely new light to the case, right? That shows that the individual you're representing is in fact innocent. And so if this ID witness issue, right, is going to be that, then perhaps, but it would be a pretty hard mountain to climb, I think. Yeah.
You gave an excellent presentation.
Oh, thank
Your
you.
work was so good and interesting. In your presentation, the first two cases that you mentioned were the Royal Clark and the Archie Williams.
Mm-hmm.
And I picked up on you saying specifically in both instances you had full cooperation with the district attorneys. Are there any projects that you're working on right now or would like to work on that you're just not getting to where you need to be because you don't have full cooperation of the district attorneys that would need to cooperate?
What's that question?
So he asked that when we brought Archie Williams and Royal Clark's cases to the DA to get the fingerprints tested, that we did get their cooperation and that they worked with us to get those fingerprints tested. And so he wants to know whether or not there are other cases where we are currently working on where we're not getting that level of cooperation. And so more often than not, we don't get that level of cooperation, I have to say. And so we feel like Archie Williams and Royal Clark was a real special case, in the sense that because we had the physical evidence, right, that definitively pointed the case away from our clients and toward an actual perpetrator, when you had that sort of evidence, I think it's really hard for the DA's office to say, no, right? And so in a lot of our DNA cases, we do have to litigate them, but once a DNA hit happens and it shows that our client is actually innocent, they actually, prosecuted and arrested the wrong person, because we have that physical evidence that definitively shows that our client is innocent, and sometimes, more often than not, the DNA evidence shows it actually inculpates someone else, right? Someone else. And when you look at the totality of the facts in the case, it makes more sense that this other person actually committed the offense. It's easier, right, for the DA to come out and say, we were wrong, we made a mistake 30 years ago, 20 years ago, 10 years ago, right? Predecessor made a mistake, let's correct this injustice. I think the harder cases are cases involving Brady evidence. And by Brady evidence, I'm talking about exculpatory evidence that the state withheld from the defendant, right? Either because they didn't know or think that it was going to be exculpatory, or because the police had it and the DAs actually have a duty, a legal burden, a legal duty to find out everything that the police has on a case. Because the police had it and the DA didn't know about it, it was never disclosed, right? In those cases involving exculpatory evidence, Brady evidence, those are more difficult cases in which the DA is going to say, we were wrong, we should have turned this evidence over to you 20 years ago. Oops, sorry, right? I think those are more difficult to get cooperation from, yeah.
So I have a question for you. When these people come out of jail, who is going to pay them for the time that they have in jail wrong?
Right, no, so there's a couple different ways, right? So there's a state compensation statute in Louisiana. And I have to tell you, this is one of the things that we will be working on to improve in the years to come, because we actually have one of the worst compensation available to wrongfully incarcerated individuals. So Wilbur Jones, right, he did 46 years in prison for something he didn't do. He went to prison as a 19-year-old man. He came out literally at age 65, right? He lost his entire life his life, his chance to have a family, his chance to be educated, his chance to have a job, right? He went in as a young man, he came out as an older man with a host of medical issues on top of that, right? And so for Wilbur Jones, the compensation that he's eligible for through the state of Louisiana is $25,000 per year for 10 years only. So despite the fact that he did 46 years, he's only going to be compensated for 10 years. So a maximum of $250,000, right, over the span of 10 years. Another part of that compensation is he'll get $80,000 up front for loss of wages, for loss of life expense. And so he can use that money to get medical assistance, to get dental assistance, to get mental health assistance. He can use that $80,000 upfront to get job training, to get education classes, stuff like that, to try to help him get back on his 2 feet. But that's it. Most other jurisdictions, Florida offers up to $2 million. And even $2 million is not that much money if you really think about the value of your life. If you're sitting in your chairs, like how much is a year of your life worth? And we're not talking about a year of your life in some island. We're talking about a year of your life in Angola, right? In a high security prison, right? And so that's what is offered to our exonerees who come home. And so we're trying to, as I said, probably next year and the year after that, to increase that amount at minimum to meet what other states are doing. Kansas recently passed a legislation last year where they're offering, $60,000 per year for every year they were in prison, right? So if you did 46 years, you're going to get compensated for every one of those 46 years, right? Yeah.
Are churches in Louisiana involved in your project, your Innocence Project?
He wants to know whether or not churches are informed about the Innocence Project New Orleans' work. Involved. And so in working with, in the last couple of years when we've been doing this eyewitness identification legislation up in Baton Rouge, the Catholic bishops have been very, very helpful and been lending a hand. I think there's another organization called MICA in New Orleans, and maybe it's a statewide organization that we have talked with, who's been very helpful. And so we do try to involve religious leaders and religious members. Yeah.
I was going to ask, and this kind of touched on this a little bit, I was going to ask if there was, in the past legislative session, any other legislation you want to highlight in terms of things you're happy about or things you're disappointed about, and things that you would like to see in maybe next year or the year after? You touched on one, I was wondering if there's.
Sure. So another thing that we are looking at is if the DAs, Hillard Moore and Connick, DA in Jefferson, if they did not agree to join us in our motion to vacate the conviction, there's actually no legal remedy for Archie Williams and Royal Clark to be exonerated. Because in Louisiana, under post-conviction statute, the only way you can get your conviction overturned is if there is a constitutional violation. So, for instance, in Brady cases, that's a due process constitutional violation. So you can use that hook to try to get your conviction overturned. In a case where your investigator or your trial attorney failed to investigate, that's an ineffective assistance of counsel claim, a Sixth Amendment constitutional claim, and then you can get your conviction overturned. And those are the two primary ways you can get your conviction overturned, but you need to have this constitutional legal hook for it. Now, in Archie Williams and Royal Clark's case, it was a fingerprint evidence that just was never, in Archie Williams' case, it was tested, it was run through the system back in 1981, it just made no hits, right? And so they did everything they could in 1981. We just asked them to run it again with the hope that maybe there'd be more fingerprints in the database system, and obviously there was, and it obviously made a hit, right? But Archie had no legal right to that. It just happened because Hillard Moore decided that we're going to give this guy a chance, and because the other evidence in the case raised questions about his innocence, we're going to see whether or not this pans out in any way, right? Same thing with Royal Clark. There was fingerprints, right? it was not I mean, the defense knew about it, so it's not an exculpatory evidence that the state suppressed, right? And the defense, there's nothing, there was no constitutional legal claim by which he could have been freed, but for the fact that DA Connick agreed to run it for us, right? And so one of the things that we're looking at, and there's actually 20 other states have this by statute, and 17 other, I believe, states have it through jurisprudential case law. They have a freestanding innocence claim pathway to getting your convictions reviewed. That means you don't need to have a constitutional legal hook for it. It could be just new evidence that comes to light. And that should be enough to get a judge or a prosecutor to reconsider the evidence. And so it's called a freestanding innocence claim statute, and so that exists in many states, including our neighbor Alabama, surprisingly. And so it's something that we are thinking about and probably going to be working toward to try to get passed. And if we can't get a completely freestanding innocence claim statute that kind of covers all kinds of evidence, then we would certainly limit it to fingerprints and say, if there are fingerprints in a case, and if there is extenuating circumstances about that particular case that shows that maybe a wrong person has been convicted, then that prisoner should be allowed to petition the court to get their fingerprint evidence run through the state database system or the national database system. And the national database system has been upgraded. In 2009, there was a huge switch in the national database system that really enhanced the number of fingerprints that were in there and enhanced the ability to really analyze the fingerprints. And then again in 2014, the FBI again really improved their database system. And so there are a lot more fingerprints in the system totally across the country, but not only that, the ability of I don't really know the technical parts of it very well, but my understanding is that the ability for them to read the fingerprints has heightened. Yeah.
Human nature being what it is, perhaps 9 out of 10 incarcerated individuals are innocent in their own minds anyway. How do you review these cases, and how do you hit upon the particular cases that you find valuable? Sure.
No, I mean we're looking for a needle in a haystack, honestly, and we get lucky, and we spend a lot of time screening these cases, and so the prisoner would have to write to us and kind of give us his or her story, right, about their case and why they believe they're innocent. Once they write us a letter, we then send a fairly intense application to them that kind of goes over the procedural history of their cases, the facts of the cases, and all of that. And once we get that information and we think they're just, and when you read some of these cases, trial transcripts, you're kind of appalled by the lack of evidence in these trials. You read these trials that happened, over a span of 12 hours or in a span of, even 24 hours, right? You read them and you think, this is it? There's got to be more. And so particularly in those cases, we start doing a fairly extensive Public Records Act requests. We try to get every single piece of paper in the law enforcement files, in the DA files, at LSU, wherever it is, trying to learn about the case. And then if we think there's something there, we start re-investigating the case. We invest a lot of investigative resources. Investigators go talk to all of the witnesses in the case over again. And sometimes if there is physical evidence, some of our easier cases are the DNA cases, right? Because if it's a single perpetrator rape case or a single perpetrator armed robbery case, and we know there was physical evidence that was left at the scene that can be tested, right, to show that our client is innocent, it's just a matter of finding that physical evidence. Now, I make it sound really easy, but sometimes it takes us 2, 3, 4, 5 years to look for that evidence in the evidence lockers of law enforcement agencies or the clerk's offices. So once we find that evidence, and a lot of times we can't find the evidence, right? Especially in a case from, we spent about 5 years looking for Wilbur Jones's evidence in that case. There was a rape kit in Wilbur Jones's rape case, and we couldn't find it. And we eventually found a destruction order from the judge that was buried in the BRPD's files, right, that show that the evidence was destroyed, a few years after he was convicted. And so, right, in the DNA cases, if we can find the evidence, if we can test it, those are the easiest. And the non-DNA cases, it takes a lot more work of just reading every single piece of paper in the case, and then talking to witnesses, reinvestigating it, using experts if we need it. Yeah. Sure.
We have time for one more question.
Regarding the post-exoneration compensation, that amount that you talked about them being eligible for, are they automatically given that, or is that something that you sue for, and where is it come from?
Right, so it's not automatic. Not every single individuals who've been exonerated who come home get that amount. We actually have to file a separate legal pleading. And so we have to file another complaint in the court in the criminal district court, in which the conviction was vacated, and then the judge would have to find by clear and convincing evidence that the person was in fact innocent. Not always, right? I think that it's not usually the DA's office that actually opposes, that they pass that off onto the AG's office. And so it is the AG's office that usually fights and opposes this petition all the way up. And so a lot of times we spend a lot of resources litigating to get that. From all of our clients, all of IPNO's clients, we've been able to get compensation for our clients, but not every exoneree who comes home in Louisiana gets that. Yeah.
How?